Journal continues.
We want to welcome Bruce Fein, who served in the Reagan administration, a constitutional lawyer, and as a way of background, what was your title and what were your responsibilities when you served in the Justice Department?
Well, I had served as long ago as the Richard Nixon administration, where I was in the Office of Legal Counsel. I was later on in the Office of Legal Policy. Under President Reagan, I was Associate Deputy Attorney General, and my responsibilities were wide-ranging concerning the general policies that were administered both in the criminal and civil division, and developing basic guidelines for the philosophy that we wanted to see enforced in litigation.
We want to focus on the broader issue of constitutional checks and balances, but certainly talk about the story that is dominating the headlines this morning. But I want to go back to something that you said regarding presidential authority. And these are your words. Since 9/11, the president has acquired too much power. He has encroached on the power of the Congress to make laws and on the power of the courts to interpret the law, a scenario that you say the Founding Fathers foresaw and warned against. Please explain.
Well, the Founding Fathers worried against the combination of judicial, legislative, and executive power. They define that as tyranny in Federalist Papers. And if you look at a broad range of areas where the president has asserted power since 9/11, they're eerily reminiscent of what the Founding Fathers described as tyranny. Let's give examples. He issues signing statements saying, I'll sign a law, but I won't enforce those provisions that I decide are unconstitutional. So he ends up enforcing a law that Congress didn't pass because they passed all the provisions, and he decides on his own whether this is constitutional or not. He doesn't leave that to the courts. When he uses his authority to detain persons as enemy combatants, it's on his say-so that he sends them to Guantanamo Bay. He says, you are engaged in hostilities or providing material assistance to terrorists, and I'm deeming you an enemy combatant. You're at Guantanamo Bay. You have no lawyer. You have no access to court. You have a combatant status review tribunal. These are illustrative of those examples, and I'll give you one other that's very worrisome, and that is the idea of extraordinary rendition, where the United States as a policy kidnaps, transports to dungeons, tortures, and leaves people out in the cold beyond the law at all. It would be as though we were traveling to Paris and Russian President Vladimir Putin plucked us off the street, sent us to Belarus for prison forever. And these are very, very worrisome combinations of, the legislative, judicial, and executive authority beyond any kind of control. And that simply has to be rolled back. Checks and balances are what I call the scientific method for discovering political wisdom and preventing injustices. One branch needs to check the other, not totally dominated. And what we're seeing, for example, today with regard to the oversight of the firing of the U.S. attorneys is this invocation of executive privilege by the president saying, I'm not going to let critical individuals in the White House testify, which leaves people in the dark. And government in the sunshine is the way we can protect against abuses.
Unless I'm mistaken, executive privilege is nowhere in the Constitution. Is that correct?
It's nowhere written there. The United States Supreme Court in 1974 deduced it from the structure of the Constitution, but it's not an absolute privilege.
So what is
a qualified privilege?
How do you define it?
Well, in this circumstance, the president is entitled in some respect to ensure the confidentiality of communications between himself and his aides. And it, however, bows to compelling government interest. In the Nixon case, the Supreme Court said a grand jury or a trial in a criminal case could demand communications between the president and his aides. The idea, Steve, is to encourage candor because people may be reluctant to be fully straightforward if they feel they could be politically embarrassed with disclosure. But in this case, we don't have a claim that there's going to be state secrets revealed if Karl Rove testifies or Harriet Mier. It's really a question of domestic political concern over manipulation of U.S. attorneys for partisan advantage instead of even-handed enforcement of the law. The law in this case by the Supreme Court is very sketchy, but in my judgment, it's an instance where if Congress doesn't take remedial action of the kind that I have proposed to the American Freedom Agenda, the administration will win, because if this goes to litigation, it'll be years before there's a final resolution and the issue will be stale.
Well, listen to what the president said yesterday from the diplomatic reception room at the White House in which he discussed executive privilege.
I recognize there is significant interest in the role the White House played in the resignations of these U.S. attorneys. Access to White House staff is always a sensitive issue. The President relies upon his staff to provide him candid advice. Framers of the Constitution understood this vital role when developing the separate branches of government. And if the staff of a president operated in constant fear of being hauled before various committees to discuss internal deliberations, the president would not receive candid advice, and the American people would be ill-served.
Your response.
Well, I've served in government for many years and spoken to many who served in the White House, and I've never had anyone say, Bruce, if I thought my communications with the president would be disclosed, I wouldn't be straightforward with him. The claim that executive privilege is essential, as President Bush indicated, to get useful information, I think, is largely bogus. Those people who are aides to the president have a duty to tell him what they feel, and he can always waive the privilege anyway so that no one knows for certain whether or not their communication will be held confidential. And in my judgment, it's clear that the need for government in the sunshine for assurance that justice can be above suspicion outweighs any modest need for confidentiality here to encourage candor.
So Fred Fielding, who's the new White House counsel, you served with him in the Reagan administration, says to members of Congress, you can question Karl Rove, you can question Harriet Miers, you can ask whatever you want. It has to be in a closed-door session and no transcripts. What's wrong with that?
Well, first of all, you want a transcript and you want it open because there may be other persons, and we know several involved in the firings, who may be able to contradict those testimony. And this is the way in which you discover truth. To have it hidden from the American people will encourage the suspicion that they aren't getting the full story and make it far more difficult to correct or to discredit, if they are misstating the facts, by other witnesses. Moreover, if you have a situation where you're not even transcribing the testimony, it may be difficult to decide exactly what was said. You're just relying on memories. And it's very odd that you would have an issue of such importance subject to such rather loose methods of investigation.
We're going to get to your calls in just a moment, but before we do so, ultimately, where do you think this is going to head?
I think this is probably going to go to court, and it's going to illustrate, in my judgment, the need for reforming the way in which executive privilege claims can be dealt with, because when you get to court, the administration wins just by virtue of delay. If we're here in a year and a half when the Supreme Court decides this, whether it's favorable or unfavorable to the administration, it's not an issue anymore. The president out of office and the information is stale.
202-737-0002 is our line for Democrats, and for Republicans, 202-737-0001. Our conversation is with constitutional lawyer Bruce Fein, who served in the Nixon and in the Reagan administrations. Coon Rapids, Minnesota. Good morning.
Good morning.
Good morning, caller. If you could turn the volume down on your television set, we'll hear you much better.
Okay, hang on a second here.
You know what I'll do? I'll put you on hold. I promise I'll come back to you. Let's go to Monterey, California. Good morning.
Hi, thank you for taking my call.
Certainly.
Mr. Fein, I watched your press conference yesterday, and I'd like to ask you to clarify something. You said that you wanted to see trials for terror suspects to be held out in the open with all the evidence being declassified. I was wondering what your thoughts were, because in 1998 we had on a satellite phone, yet we lost this as a source after it was leaked. Do you advocate treating terror suspects as regular criminals and having all of the secret agents opened up and potentially losing sources and methods because of this?
Well, we have the Classified Information Procedures Act, with safeguards against the worry that you've rightly pointed out. And for example, we have prosecuted in civilian courts with the Classified Information Procedures Act the culprits involved in the 1993 World Trade Center bombings. We prosecuted Zacharias Moussaoui in a civilian court. We're prosecuting Jose Padilla in a civilian court at present. He's accused of providing material assistance to a terrorist organization. And the fact is, we've been able to show over 20-some years that the Classified Information Procedures Act can protect sources and methods consistent with a fair trial. There may be extraordinary circumstances that justify departing from the ordinary way in which we honor our commitment to avoiding injustice by having fair processes. But the administration has never been able to show that the Classified Information Procedures Act is unworkable.